Good afternoon to you all, and thank you for joining us. A little bit about me and a little bit of housekeeping before we sort of delve into things. I qualified as an English solicitor many years ago, and for the last 18, 19 years or so, I've done lots and lots of training, both in England and in Scotland, on various matters. I've also lectured on Scottish land law. I come at property, and I come at both residential and commercial property issues from quite a defensive position, in that I do a lot of work with professional indemnity insurers looking at negligence claims against conveyancers. And that is in the context of England and Wales and also Scotland and also Northern Ireland. So I do know a little bit about professional negligence, what goes wrong, why it goes wrong, and what can be done as a consequence. As Stephen mentioned, the concept behind the forum was this. For many years, I've delivered webinars, and webinars are me, as one of Stephen's colleagues rightly says, droning on for an hour or so about legal topics. And I was asked to attend a forum for lawyers that dealt with compliance. And I put my two penneth in during the forum on various issues relating to property-related matters. And I thought, hey, what a great idea this is, because people were talking about all sorts of different things, come up with all sorts of ideas and solutions. So I suggested to Stephen that why don't we try a residential conveyancing forum? And we did, and it was an absolutely resounding success, to such an extent that we now hold them on a monthly basis. We also hold forums for commercial property lawyers, for support staff, for local authority lawyers, etc. And it has just ballooned, to be honest with you. The first thing and the most important thing is it is your forum, and we are able to talk about any issues or problems that you have. And let me give you examples of the sorts of things that we've discussed recently in connection with other forums. Issues associated with practice, issues associated with case law, issues associated with product, particularly sort of case management systems and software systems that firms have been trying and utilizing. And it's been really useful for firms to sort of share comments about product that they've purchased or product that they're thinking about purchasing in the sort of legal sector. The other thing that we can do, and I'm very keen to do, is to introduce people who are experts in particular areas to come and talk at the forums. Not again to sort of talk for an hour or so, but just to be there to participate in whatever discussions or whatever topics people would like to talk about. So again, if this is a success, and I'm confident that it will be, then we will be getting people to come along to do a slot and to attend and to listen and to join in the discussion. So if anyone would like to put their head beyond the parapet and get involved, or if anyone has got any ideas for people to get involved, hey, that's absolutely fantastic. My plan is, if this is successful, this will be a monthly free event, which leads me to another important point. Stewart Title, I've worked with Stephen, I've worked with for a number of years, and I'm absolutely delighted to be associated with them. They sponsor a lot of events and training that I do, and the reason that I'm delighted to work with Stewart Title is twofold. One, they're a good company and nice people to deal with. And secondly, as far as these events are concerned, they're not massive pushers, not massive sales drives. As Stephen mentioned, John and Liz from Stewart Title, who look after Scotland, are in attendance today. But I'm told that, really, it's not a Stewart Title event. It's certainly not an IQ legal training event. It's an event, it's a sort of service that is being provided for lawyers, practitioners in Scotland. I am aware that there is a forum in Edinburgh. There has been a forum in Glasgow. I'm not sure whether that has remained live or not. I can't really decipher from the website whether it is active or not. The whole idea is this is a facility for all lawyers in Scotland to talk about any issues or any problems that they've got. So, first of all, on slide here, contact details are provided for Stephen, who's acting as chair, for John and Elizabeth, who are sort of, as I say, looking after Scotland on behalf of Stewart Title, and I've put my email address there at the bottom of the slide. The important point with regard to this is, if you have any issues or problems that you would like to discuss at the next forum, then drop me a note by email and we'll incorporate that topic for you. Also, the other thing that I'm quite happy to do is to go scurrying off to do some research on areas and issues. And I have staff that can help me with regard to that. So if you're dealing with a particular problem or issue, or there's a common thread coming to me from practitioners, I'm happy to spend time and energy looking at that problem and attempting to come up with solutions. So that's the purpose of the forum, to be honest with you, to give people an opportunity to discuss problems or issues. And the last residential conveyancing forum I did, there were a number of practitioners that were saying, hey, look, I'm dealing with this file. I've seen this on a title, or I've got an issue with regard to this. What would you do? And the beauty of the forum is that practitioners are keen to help. When I first started doing this, I expected people just to simply sit and listen and be very unwilling to share ideas or to share solutions or to share experiences with regard to product. I was shocked as how wrong I was, because everyone was willing to share. And I think that's really part of the beauty of the conveyancing work that we do, that it's not contentious in most circumstances, it's not confrontational, and therefore there is a willingness to share, which is brilliant. So what I'd like to talk about today, to sort of start the ball rolling, if possible, are a number of issues. The first thing that I'd like to do is scoping the retainer, or checking on terms when you're onboarding conveyancing clients. I note that the Scottish Law Society have looked at this. I've just had a number of meetings with professional indemnity insurers on this very topic, and I have some ideas that I want to share with you. I then want to talk, if we can, about mineral reservations, and I'm delighted to say that John Logan's with us from Stewart Title, and Stewart Title have a product with regard to mineral reservations. We might have an exploration of that. Problems with regard to concluding missives, again, huge issue and huge problem. We'll have a look at that if we can. And then I'd like to talk a little bit about title indemnity insurance and what it does and what it is. And again, here, it's not a Stewart Title sales pitch. It's my ideas, my experience, my involvement with regard to title indemnity insurance. So hopefully everyone can hear me. Hopefully everyone can see the slides. Everyone's sitting comfortably. If you have technical issues or problems, then Stephen is sitting in the sort of vanguard of the presentation to assist. The event is being recorded. If you miss anything or have to take urgent calls, or indeed have colleagues that can't attend, do feel free to contact us and we will make the recording available to you. As I say, if there are topics for the next one or issues that you'd like to discuss now, just fire away and we're happy to deal with them and happy to discuss them. So slide, please. The first thing I want to talk about is the retainer, or your terms with regard to conveyancing. And I have to explain that I come at all conveyancing transactions, resi, commercial, no matter what the jurisdiction, from a very defensive perspective, because I deal with negligence claims. I see what goes wrong, and I see what the attitude of the courts are to claims, and indeed what the attitude of professional indemnity insurers are with regard to claims. And I think there are a number of basic principles to set out from the start. Firstly, the value of most negligence claims concerning residential conveyancing transactions is quite low. You're not talking about huge sums of money with regard to claims. And therefore, what tends to happen with regard to professional indemnity insurers is that they will have a look at the claim and say, it's not economic for us to defend these proceedings, even though there's some merit in doing so. So you often find that insurers are willing to settle claims when I and others will perhaps be maintaining an argument that the proceedings ought to be defended or the claim should be rejected. And therefore, I think we've got to be careful about taking on work and also making sure that our relationship from the client is clear from the start. The second thing I think that is important is that where we are setting out our terms, to stick to and adhere to them, something called mission creep, which we'll explore in a moment or two. So the first question that I'd like to put to you with regard to onboarding clients is, to what extent do you think that you're comfortable with your terms relating to receiving instructions from conveyancing clients? How many people provide clients with information sheets about the conveyancing process, about particular issues or problems that can be encountered? I'm very interested in this. I did some work for a firm in Glasgow a few years ago, and it's quite an interesting bit of work, because we were looking at sort of trans-jurisdiction transactions. So we're looking at Scottish clients buying probably in England and vice versa. And again, the key point there was, well, how do we transmit information to a Scottish client who's buying a property in England and vice versa? And one of the things that we agreed was the provision of an information sheet right at the start when we're onboarding the client to explain the differences in the process. So again, I'll ask the question, anyone can join in the chat if you wish. What about this issue about the provision of information, uploading information, upfronting information for clients in the conveyancing process? Do we do it, or is it simply a question of these are our terms sent by email or hard copy correspondence to the client, and then we sort of explain the process as it goes along? So can anyone sort of assist me on that in the chat facility? I'm very interested to see what we do with regard to onboarding clients and with regard to this idea about our terms or contractual terms with the client. Of course, we're obliged to set out those terms. But while I'm waiting for a response to this, there are two things that I would say to practitioners. In my experience, most firms are very good at, yeah, thanks, Jill. In addition to, I'll come back to you, Jill, in a moment or two, but thank you for that. What I always say to people is, in addition to telling clients what you're going to do, I think it's an important point to tell clients what you're not going to do. Because some clients perceive your role as sort of project managing the transaction. And to an extent, that's correct. But I would always maintain that we've got to tell clients and be realistic about what we're not doing. Our role with regard to the transaction. Are we going to be inspecting the target property or are we not? Hi, Jill. Thanks for this. We send sale and purchase info sheets with terms of business. Yeah, I think you've got to do that. And the other thing that I would always do is send my client a copy of the agent's particulars or the details of the property and ask them just to check it over. The reason I do that is I dealt with a claim a few years ago where the client had got a set of agent's particulars from a property centre, and the particulars were a sort of paper copy. But there was an online version of the particulars, and the lawyer had downloaded or had sent to them the online version, which was different. And there was a sort of mismatches between the information between the two. So I'd always make sure that my client sees what I've seen from any agent if it's been sent to us. Cheryl, hi, Cheryl. Just have a look at this. There's a lot about what is and what's not included. Yeah, that's brilliant. Yeah. I'm just having a look at what else you're saying there, Cheryl. Yeah, explaining a bit about I think you've got to do that, okay? And the other thing that I think is important, and again, the Law Society of England and Wales are all over this at the moment, is do you know your client? And I'm dealing with a lot of firms all over the place where they're not actually seeing the client, they're dealing with the client remotely. And one firm that basically is a conveyancing factory is so terrified about a decision that went before the Solicitors Disciplinary Tribunal that they're now saying we can't do that anymore. We've got to have some form of virtual or real contact with the client. And I think that's important too. But I'm glad, Cheryl and Jill, that you're providing clients information at the start of the process and explaining a bit about the process too. There is a danger of overkill, isn't there? And again, I've seen a judge saying, look, this was in a Prof Neg case, look, the engagement letter, the report that you've submitted to the client in this transaction is so heavy, is so wordy, is so voluminous, so huge with regard to volume, that no one in their right mind could be expected to read it. So I think I'm a great believer in front-loading information to the client about the generality of the transaction, which is basically what Jill and Cheryl are saying to me. And also as the transaction progresses, providing clients with information relating to that. I think that's so useful. And making sure that we're effectively communicating. And here's my first tip of the day, really. Given my experience dealing with professional negligence claims, it is absolutely essential that when you're providing information to the client, you ask the client to confirm that they've received it, that they've read it, and that they've understood it. I would also ask a client if they've got any questions relating to the information that's produced. So Jill and Cheryl, can I ask you two that would you ask a client when you're providing this information to the client to acknowledge receipt? Or would you ask them to confirm it's been received, it's been read, and it's been understood? And anyone else, what do you do about that? But I do worry that where we're providing information to the client is just sort of not digesting it, and that we don't have evidence that they've read it and understood it. Sometimes the clients will just say they've read and understood it when they haven't, but at least if I've got that evidence, I can't at a later date have an argument from the client to say, hey, I didn't read it or didn't understand it. Yeah, received and accepted, I think, and understood as well, Jill. I think that would be the point I would make there. And I would always ask a client, look, do you have any questions? The other point on this that I think is important when we're talking about onboarding clients is to make sure that we deal with collective clients in an appropriate way. And what I mean by that is making sure that when we are accepting instructions from, say, Mr. and Mrs. Smith or Mr. and Mrs. McNaughton, whoever it is, that we understand that these aren't collective clients. These are two individuals that have to have appropriate conversations to make sure that we're happy with capacity. We'll make sure that we understand their levels of knowledge and significantly their attitude to risk. One of the things I say to conveyancers all the time, is that your job isn't, other than in issues concerning title, to determine the extent of risk. It's just to highlight risk and then to suggest to clients, hey, look, specialist advice can be sought where that's necessary. So the second point I make here is making sure clients understand what we're not going to do as well as that which we're going to do, and also the limitations of the conveyancing process. I think that's important because a lot of clients just don't get it about just what we're doing. Okay, Debbie, hi Debbie. Our clients accept electronically if they proceed, deem that they've accepted our terms. Yeah, okay. So what you're saying, they accepted electronically. I'm comfortable with that, Debbie. The only thing I would say is I would like the client to confirm not only that they've accepted it, but they've understood it. And again, I make no apologies. I'm defensive because I see county court and high court judges in England and Wales who are turning around to say, well, all right, the client is saying they didn't read it, or they did read it but didn't understand it. What steps or what measures did you take to make sure this information was in a format that the client could understand and that there was evidence that the client was confirmed to you that they did understand it? So I'm always a bit wary about that, and as I say, just a little concerned about it. Now, some firms, when they're sending out terms of business, will ask clients to sign each and every page to confirm that it's been read and understood. One firm in Cardiff that I do some work for sends this is quite bizarre, but I kid you not, they send the client a quiz sheet, okay? And the client has to complete it and they can only complete it if they've read your terms of business, your retainer letter, the report that you've sent to the client before Mrs. have concluded or whatever, okay? And now I don't like that idea because I think, hey, half the clients that I've acted for over the years, if I sent them a quiz sheet out to them, they'd get it wrong. And then what do I do? But you get the point, don't you? This idea about ensuring we're being effective with regard to our communication is so important. Uploading information, making sure that we're protecting ourselves and our firm by making sure that information that's sent to the client is subject to some form of reaction from the client rather than a simple acknowledgement. Yes, I've read. Yes, I've understood. And no, I don't have any questions would be what I'd be looking for. Interesting point you make there, Debbie. Sometimes we get so familiar with our standard documents that we sort of forget about it, and sometimes it's useful just to have a look at what we're sending out to clients and just ask ourselves what we think. Hi, Kimberly. Right, as a page for terms an instructor to act on their behalf and agree to be bound by the terms. Yeah, I think that's fine, Kimberly. That's great. But I would love it if you also said that the client is confirming that they've agreed to be bound by the terms and that they've understood them. Okay. Because again, I'm worried that at some point in the future, the client turns around and says, hey, I didn't get it. There's something else I'm just thinking about there, let's thorny subject for everyone, fees, okay? I don't know what it's like in Scotland at the moment with regard to fees, but in England and Wales, I think there's been a bit of a retreat. Cheryl, yeah, I can. There's loads of case law on it. Drop me a note by email. I'll send you it. I'll tell you what I can do on the next occasion. I can show you some cases as part of the sort of slides. But if you send me an email, Cheryl, I'll send you the case law, etc. Okay. And what we might do is I might get a professional indemnity insurer or a broker to come along and have a chat with you about it. because I know that they're worried about it. What insurers are saying to me at the moment is negligence claims against conveyancers are sort of still on the up. There's still high levels of claim, but claims have changed. In the past, claims would invariably be relating to procedural errors, mistakes that are made with regard to a report on a title, and failing to do searches, failing to register, this sort of thing. And what there's been is a bit of a shift. And the shift now is not procedural error, but communication error. Clients saying, I didn't get it, either physically didn't get it, mentally didn't get it, or things like that. And that's interesting. And certainly what insurers are asking me to do is to talk to lawyers more and more about soft skills, about what I call sort of simply client hand-holding during the process. So yes, Cheryl, drop me a note by email. I'll happily do that. And again, if people are interested, I'll make sure that we share that in readiness for the next forum. Okay, good. The next thing the point on slide here is mission creep. Okay, and again, I noticed this was something that the Scottish Law Society was saying, and certainly insurers are telling me about this all the time, right? And what it is, quite simply, is this: we have terms of business that the client acknowledge and understand and accept. Okay, and we start the conveyancing process. And then what happens is that there are developments within that process that mean that we go beyond our terms of business. So, for example, in England and Wales, one of the things that most practitioners will say to a client is, I will not inspect the property. You will be relying on survey and valuation and your own inspection. And it's one of my sort of pet hates that firms don't drill into clients how important that is, and how that they need to understand that it's not our role to physically inspect the property. Now, it could be necessary depending on what the problem or issue is, boundaries being the obvious one. But if that is the case and you've said you're not going to inspect, then what you've got to do is you've got to set out the purpose of inspection. I'm inspecting your property because on the western boundary there's an issue with regard to the location of the boundary, or whatever the problem is. If you do that, then I think it's fine. I've heard professional indemnity insurers say, if you just inspect without telling the client the purpose for the inspection, there's the potential for vulnerability, on the basis that you missed something that perhaps a reasonable conveyancer would have spotted, or the client asks you a question and you provide a response that would be wrong. So Stephen, hi Stephen, it's getting the client to say they understand the terms of a tick box. It's fair to would understand the nuances. Is it fair to assume a layman would understand the nuances of a conveyancing process? Great question, Stephen. Thanks for that. Yeah, I don't think it's, well, Stephen, I think it is a tick box exercise, okay, in that you are asking the client to confirm they understand, and there'll be occasions where the client doesn't understand, okay, but they've just said it because you've asked them to say it. But I'd rather you do that than have a situation where that issue isn't identified, because there is a danger then that the client comes back and said, you sent me that 40-page report, I didn't read it. I signed your terms of business, I haven't read them. And I've heard judges be quite sort of sympathetic to clients in that situation. Whereas if you've asked the client directly, I'm going to assume you've read or understood this, unless you tell me to the contrary. I'm asking you now if you have any questions, where the client has sort of confirmed via email, they've read it, they've understood it, they don't have any questions. It's then quite difficult for the client to turn around and say, hey, I didn't get that, and therefore I think you've been negligent. Okay. In the past, courts were very, very protective of clients and would throw lawyers under the bus. I've seen situations where a client has said, I had a meeting with my lawyer, we didn't discuss that issue. And the lawyer is saying, I'm fairly confident that we did understand that issue. In all my years where that issue arises, it would be a matter that I'd always discuss with the client. And I've seen a judge say, and I've read judgments where the judge has said, well, that's the debate and that's the issue. There isn't anything on file, there isn't anything on the case management system that says that the lawyer did that. So it's all well and good the lawyer saying, this is what I usually do. Is there any evidence to say this is what the lawyer actually did on this occasion? And if there isn't, then I've heard a judge say, well, hang on a minute. The client only had 1 or 2 transactions on the go on the date of this meeting where there's a dispute as to what was said or what wasn't said. I've just looked at the lawyer's time recording system, and at that date, he had 50 or 60 active files. And therefore, who do I believe? And I've seen judges say, I'm going to take the client's view on this because there's no way that the lawyer can remember properly, and there's nothing on the file to say he did this, even though he's saying that's what he usually would do. Now, I did see a case last year where a judge in a county court action said, this is a professional person who is saying this is what he always did, and there was a checklist on file to denote that he'd done this, and therefore I'm going to give the lawyer the benefit of the doubt. And that was a breath of fresh air, to be honest with you. The other thing that's been interesting again in England, and it'd be interesting to see, I'm going to do some research about Scotland, but in the past, it didn't matter what you charged for conveyancing transactions, the duty of care that you owed the client was the same. So in delict, the duty of care that you owed would be exactly the same, whether you were charging the client £10,000 or £250. It's been a case recently where a judge has said, if a client is wanting a basic conveyancing service and is paying, in essence, a basic fee for that service, that's what they get. And that's quite refreshing, to be honest with you. As I say, it's a sort of change from the sort of tack. And I think what I've seen over the years is judges being a bit more defensive of conveyancers. In the past, the judge's attitude was, you've got professional indemnity insurance. It's not really going to hurt you if I find for the claimant or the applicant in this particular case, and therefore that's what I'm going to do. I mean, I saw a case last year where the judge basically said, I don't care what the law is, your client suffered a loss of £2.5 million and you've got a professional indemnity policy, therefore I'm going to fine for the claimant. That's basically what he did. Okay, so does anyone else have any questions on that then? I would be interested to see what firms do with regard to the concept of mission creep, and just to be careful about keeping the retainer or your terms of business under review. And the other point that I'd like to make with regard to this, where you have policies with regard to how you communicate with clients. So, for example, emails, we will respond within 24 hours or 48 hours of a working day in connection with emails that we receive. I have seen firms who get pressure from clients. We all get pressure from clients, and therefore they say to the client, well, all right, that's our policy, but from now on, we'll communicate with you within some 12 hours of a response in a working day. That sort of thing is dangerous. Just as with terms of business, if you have terms of business, you stick with them. Do be careful with regard to mission creep. Thanks for everyone for joining in on that. It was really interesting. And Cheryl, do send me an email about the case law, and I'll find that for you if I can. And do have a review of your documentation and just, have a look at it. Is it client friendly? If I have to submit a file or a report to an insurer, or I'm before a court, have I got evidence that the client has understood it? Have I provided or effectively communicated with the client sufficient information? The next thing I want to talk about are mineral reservations. And have you seen an article written by a lady called Pamela Todd at Harper McLeod? Really interesting article on mineral reservations. If you haven't seen it, I'll ask Pamela for permission to sort of share it with everyone. But I think it's on their website. Don't know. Has anyone seen it? Mineral reservations are an issue, and they're an issue in England and Wales, they're an issue in Scotland, an issue in Northern Ireland as well. And the problem seems to be, well, if I can share my experience with regard to minerals and reservation of minerals with you, the problem seems to be that with regard to title in connection with the surface, then it's fairly easy to establish possession. But when we start talking about ownership of subterranean assets such as minerals, etc., there then becomes a problem. One of the things that's quite bizarre, I just to let you know that I'm a consultant with the Land Registry of England and Wales, and one of the things that's quite bizarre is that it is possible in England and Wales to claim adverse possession for mineral rights. And when talking to the Land Registry about this, they explained that if you had a piece of land, a parcel of land, adjoining another parcel of land, and you had a mine shaft on your land, and there was a tunnel on your land that went underneath the adjoining land, then you could claim adverse possession in connection with any minerals that you were able to work via the tunnel that was accessed from your mine shaft. Quite a bizarre scenario. You know, how on earth would the landowner of the surface be aware of that? The land registry never got back to me. But similar situation with regard to Scotland. So again, what do you do on this one, just from a practitioner's perspective? How do you deal with mineral reservations? Anyone? And is it a problem? I mean, I can understand if I'm buying agricultural land, if I'm dealing with quarrying companies, etc., major issue, I get it. But I wouldn't think it would be a vast issue or a huge problem for residential conveyancers, perhaps in a rural area rather than an urban area. But what are people finding? Because I was told this was a real problem. While I'm waiting for answers, I'm delighted that John Logan, who is the country manager for Scotland, I think, John, aren't you, for Stewart Title? John, do you have a project? All right, Stewart, thank you. Can you tell me why, Stewart, they're a problem in your experience? And while we're doing that, hi, John, if you put your microphone on for a moment, please, if that's possible. Good afternoon to you. Do Stewart Title have a product with regard to minerals and mineral reservation and mineral rights? Hi, John, I'm just waiting to hear from you. Can't hear anything at the moment. While I'm doing that, so Stuart, if you can put on the chat box there what the problem is, or you can turn your microphone on, and I'd be interested to hear how it's a problem and what the resolution is. But certainly I'm aware that practitioners are saying it is a problem. All right, thanks, Cheryl. No one seems to have permission. Stephen, I think people need permission to put their mics on for me. Thank you. Thanks, Stuart. In a court, how to court declare titles with a reservation, but not including express a defective. Yeah. Yeah. Okay. So is it a right? If you could ping them across to me, Stuart, that would be great. So when we talk about an express right of support, what are we saying there? That there's an issue with regard to extraction activity? Is that the problem? Or is the problem the fact that when we're looking at a title, we're unable to ascertain the position? John, I don't know if your microphone's on now, but I'd be interested if it was. Yeah, thanks, Stephen. If you'd like your microphone unmuted, if you just put your hand up, and Stephen will sort that out. I don't know if John's with us. Hi, Stuart. Yeah, carry on. I think you should be able to speak now, Stuart, I hope.
Can you hear me now?
Yes, I can, loud and clear. Thank you, my friend.
Hi, right. Okay, sorry. This is one of my pet hates, which is why I'm jumping in right now.
Brilliant.
I practice in Fife, where there are lots of mineral reservations.
Yeah.
Now, there is an inner and outer court of session case.
Yeah.
The early 1900s, Todd v. McCarroll, I have both of them here, which has declared that if the mineral reservation does not contain an express right to support or damage or compensation for damage caused to the surface, that title is defective and unmarketable. Pure and simple, that's it. It has for decades been traded in Fife with people simply ignoring it. I absolutely positively will not buy a title without a mineral with that reservation, without a title indemnity policy. Now,
I get it.
Well, for everybody else that's listening, I will say now, the concern is absolutely not someone coming along and discovering diamonds under Methyl High Street. That is never going to be the problem. The problem is, God forbid, in a recession, some smarty lawyer from one of the bucket shops saying, you've accepted a defective title, you're on the hook for our clients' losses. And that is a real risk to every practitioner every day. So I will not allow my firm to buy a title. Either the seller provides it or the purchaser provides it, or we don't buy it. Simple as that. Because it's declared defective.
Yeah. So Stuart, really what the issue is, again, that from a lending perspective, so from a lender's perspective, if you accept that title and it's subject to mortgage, you're going to be on the hook for the lender, aren't you?
Exactly.
So what is the stance? Do some lenders say, look, we're not lending?
Well, you have to report to them that no lender would lend on a declared defective title unless steps have been taken to remedy it. That remedy is a title indemnity policy, which run, depends where you get it from, 70 quid, 100 quid, something like that. Negligible sums.
Yeah, Stuart, can I ask another question? So what's the level of indemnity cover that would it be the value of the property or the amount of mortgage?
Full purchase price index linked.
Right. Okay. Yeah. Okay. That's fine.
So you've got the cover there, but I know there are certain agents in Fife who seem to think we've been doing this for decades and half of Fife would be affected. Don't care. I'm not the one that's being on taking the claim in the event that the purchaser becomes bankrupt or has it repossessed, because that's the risk.
Absolutely. Stuart, can I just tell you something? I've dealt with the matter recently in England, right, where there were 140 houses sold on a development. Lawyer number 141 says there's an issue. There's an issue with regard to the title. I'm not prepared to accept it. Lawyer for the developer says everybody else has been willing to accept it. Don't be stupid. Lawyer backs up and says, no, I'm not. Turns out there's 140 claims being made against previous lawyers. So I fully agree. Just because people in the past have said yay, or just because agents are saying there isn't a problem, doesn't mean that there isn't a problem. So Stuart, thanks for that. Stuart, if you send me the authorities, I'll have a look at them. But thank you, I appreciate it.
John, will do. They are ancient, but until there's a higher court than the inner house of the Court of Session makes a decision, they are precedent. So that's it. I'm stuck with it. But yes, I'll send you both.
Thank you very much. That's great. Thank you, Stuart. John, are you able to join us yet or not with regard to the Stewart title policy? Just interested. If you're not, that's fine. That's okay. Right. So clearly there is a problem.
Sorry, it's Steve here. I think he's having some power issues where he is. So I apologise about that, Ian. But we'll get him online as soon as possible.
What we might do, Stephen, is we might distribute to delegates that have attended today details of it, or we can have a look at it on the next occasion. But I'm really grateful for Stewart for his insight. That's really, really useful. So thanks for that. And if John's got problems, I won't bother him anymore. Okay. Thanks for that, Stephen. Stephen, can we go to the next slide, please? Thank you. Right, now then, missives and issues relating to missives. Again, what are people finding at the moment? First of all, first question, the Scottish New Bill standard clauses. Do we like them? Do we not like them? What's the view from practitioners? Are we happy with them or not? Anyone like to volunteer a sort of view? That would be great. Just waiting for that. And what are the major bugbears? What are the issues with regard to delays? What are the problems? What are we finding? So again, I'm just waiting for people to put their views. Again, if you want to speak, do put your hand up and we can make sure that you can talk via microphone. So Jill, the subject to review, are they? Is the review because of issues? Or is it something like sometimes I see where it's, there you are as a group of practitioners, run with it, work with it, and then come back to us and we'll have a look at it and chop it around to make sure it works. Yeah, I agree, Stuart, that like a lot of these things, they are sort of heavily protective of developers rather than protective of consumers. Or Stuart, I would say balanced. Okay, so what are you finding where you're going to a developer and challenging? Are they saying no, these are standard clauses and therefore we're not prepared to budge? Or are some of them being sensible? Yeah, so they're generally not being used, Jill. Okay. Right, okay, that's fine. Thank you, Debbie. So is it from a procedural perspective a major problem for practitioners, or is it a question of tweaking and revision, but we're working with them in the meantime? Debbie, do you know? Have you, Jill? So one instance of use in 10 years, crikey. Right. So that's disappointing, isn't it? So can we take it from that, Jill, that they're unsatisfactory? Do you, Debbie? All right, okay. And Debbie, happy or unhappy? That's what I thought, Leslie. I thought most developers have their own style. And I mean, again, that can cause problems. An interesting point, however, is this. Oh, thanks, Debbie. The interesting point is this, that where you've got standard provisions, okay, what tends to happen is lawyers become familiar with them, okay, and relaxed about them. And therefore, what you tend to see are claims. Whereas if you've got something that you've got to look at afresh on a fairly frequent basis, you don't have that sort of that comfort, and therefore you scrutinize each and every one, and therefore you tend to be a bit more on your guard with regard to clauses, and therefore less claims. You'd imagine the opposite would be the case, but in fact it isn't. So okay, has anyone got any idea as to when we're going to see some changes that mean we're likely to have a sort of common practice? So this review by the professional practice team, Law Society Scotland, does anyone know when that, Jill, is likely to be concluded? Yeah. That's the one thing I noticed, Bruce, that in certain in certain regions of Scotland, there's a sort of working practice arrived at. Yeah, Jill. I mean, again, got this problem in England with regard to the big developers. There's something called a pledge, a new build pledge, where the builders are saying, yeah, we promised to do this and promised to do that. And I'm often asked by conveyancers, well, what is the legal status of that pledge? And the answer is, as between developer and buyer, no real protection for the buyer whatsoever. So I think that's a problem. Yeah, okay. So anyway, what I'll try and do is I'll try and find out from the Law Society of Scotland what's happening with regard to that, and we can perhaps revisit this on the next occasion. Yeah, okay, Jill, that surprises me with regard to the fact that there's not huge take-up. Okay. And Cheryl, do you think with developers it's because your clients bought the dream house, paid a reservation fee or whatever, and therefore that they're in the sort of driving seat with regard to the contract? Do you think that's the position? So we stick with what we've got, and we're not willing to change or alter our contractual terms. You often get that, don't you, with contractual terms, the developer saying, well, everyone else is happy and therefore, sorry, we're not prepared to amend. Yeah, I think that's the point, isn't it, Cheryl? Yeah. And again, there's been all this drive with consumerism, etc. But it's a load of tut, isn't it, really, on the basis that the developer has the whip hand. Yeah, I agree that, Cheryl. Yeah. Yeah. Okay, and thanks for that, Jill. Plot sales and not liked, and therefore we're not going to see it. Okay, so is there a solution, or do you think we're stuck with what we've got, or do we have to wait and see what Law Society Scotland says and go from there? Interesting. Okay, we'll talk a bit more about this last year. It clearly is a problem. Sadly, it seems to me there isn't a solution unless someone can fire something at me. Stewart, have you still got your hand up? Do you want to make another point? I don't know, Stephen, if Stewart wants to say something else on this topic. Oh, no, sorry, Stewart. That's fine. Okay. Stephen, if we can go to the next slide, please, that would be brilliant. Yeah, I want to talk a little bit about title indemnity insurance. Not discussing Stewart title products in general, but just to discuss one or two issues. And Stephen, do chip in whenever you want with regard to this. Stephen Smith at Stewart Title. I think it's important that lawyers appreciate what title indemnity insurance, defective title insurance, does, in that it is a fix. It does allow transactions to progress and proceed, and does afford protection for clients. But one of the things that worries me is just what the level of protection is, and just whether clients are aware of what protection they've got. And the reason for this is a tale of woe at my expense from a number of years ago. I was acting on behalf of a client that was buying a hotel, and there was a right of way. Well, in fact, there were two rights of way to the hotel, and that we owned the title to one access, which was a service access for service vehicles. There was a prominent entrance to the hotel, and the right of way that we had to that was prescriptive. In other words, we didn't have an actual title for the right of way itself. It was just established due to long use. And we were worried about the access, so we took out an indemnity policy, defective title policy, and the policy we took out was for the value of the hotel that we were buying. It was a little country house hotel that we bought for £1.5 million. The client was happy to take out the policy. He needed it because he was worried that this was the primary access for customers and guests, etc. And it was quite a sort of significant access. The service access and other access were off minor roads. This was off a principal road. So we took out the policy. Client works his magic, and what was a little country house hotel all of a sudden blossoms into golf course, leisure facility, wedding venue, conference venue, etc. So the access, which had been used sort of for perhaps 5-10 vehicles a day during the week and 20-30 vehicles at weekends, all of a sudden becomes a very busy thoroughfare. The owner of the land over which the right of way ran shouts foul and says, your right of way was for a country house hotel and not this huge monolith that you've now created. And it's affecting my farm traffic. It's affecting traffic to the farmhouse that I own. And therefore, either you stop or I'm going to bring proceedings and stop you. Client notifies insurers. Insurers instruct solicitors who start talking to farmer. They offer £1.5 million to acquire a legal title to the right of way, a right for at all purposes and all times to resolve the problem. Farmer says no. Farmer ultimately litigates, costs client nearly £2 million to resolve the matter. So I always say to clients when I'm taking out title indemnity insurance, the level of indemnity that has been chosen is an arbitrary sum that may or may not properly represent any loss that you could sustain. Now, in a resi context, as we were saying a little earlier, with Stewart's point and his title insurance with regard to mineral rights, the custom is that it's market value of the property, purchase price or loan, whichever is the greater. In a commercial context, what I'd always say to my client is, how much premium are you prepared to pay? And then I would talk to Stephen Smith and his colleagues at Stewart Title and say, what level of indemnity can I have in connection with this policy? But do be careful about title indemnity insurance to make sure that clients are aware of the cover and what is covered. And as I say, the level of cover being an arbitrary sum. Stephen, any comment on that or not? Do you think I'm not barking up the wrong tree, or do you think that's a fair comment?
No, absolutely. I think it's a fair comment, Ian. And one thing that's said a lot about insurance is this concept that it is a shield rather than a sword as well. But I think we understand, and I think this is somewhere where Stewart Title in particular. It's understanding that if you need this insurance, if you need to put it in place, it's not a purchase that you're making because you're happy to make it. So what we're constantly trying to do with our policies in both Scotland and across the UK is to make it as simple as possible to order them, and realize that if you've reached this point, if you've reached this pain point in the transaction, you don't need to be talking to us. You just want to get over that hurdle. But absolutely, I think what you're saying is completely fair. Yeah.
Yeah, thank you. And the other thing, Stephen, while you're on the line, and again, I think it's important to understand that you have online products that I can just simply click onto and acquire as part of the conveyancing process. But if I've got something that's tricky or unusual, the whole purpose of Stewart Title and your team is that you're willing to talk and listen and to create bespoke policies where appropriate. Is that fair, Stephen?
No, absolutely. Yeah, that's absolutely fair. And again, I want to be careful not to go too much into a sales pitch about Stewart. Obviously, that's not what we're here to do. No. But at the same time, absolutely, we have. And it is worth pointing out that we are relaunching our system soon. And as I say, we're looking particularly at the service and improving that and making that quicker, making it so that, you know, if you reach this hump in the road, it doesn't take ages to resolve. You can quickly get the policy, and that includes, you know, varying our assumptions online. So while you're on the online system, you can stay on there a lot easier, increasing the limits we have available there. But in the event that it does become a bespoke policy, absolutely, we have 15 underwriters in our team now, 3 who are qualified in Scotland, and many more that can look at issues as well. So absolutely, we're well set up for that, to deal with those issues.
Because that's one of the things I'd always say to practitioners is, look, sometimes, you know, if you've got an issue and you're thinking, do I need a policy or don't I need a policy, or how do I resolve this? Often talking to an underwriter, and I know Stephen and the team will facilitate this if need be, that, you know, you get a view or you get a stance, so you get a level of understanding, which can be really useful. So thanks very much for that, Stephen. What I want to know now is whether or not anyone's got any burning topics. We've got 4 or 5 minutes before we finish today, and as I say, you know, I'm conscious of the fact that I've been droning on about various different things. What are the burning issues? What would you like to discuss next time? Who would you like me to bring along to have a chat? I think, from what I can gather, it might be useful if I get a professional indemnity insurer or a broker that specializes in professional indemnity insurance to have a chat about conveyancing generally. The other thing that I think is interesting, while I'm waiting for people to put topics in there, is, have you looked at the Scottish Legal Complaints Commission website? It's something that I look at. I look at the Legal Ombudsman site in England, and I look at the Scottish Legal Complaints Commission website too, looking at client complaints, because clients complain, don't they? And whether we're good, bad, or indifferent, no matter what we do, given what we're doing, clients will complain. And I'm really interested in why clients complain and what we can do to remedy it. Stephanie, that's great. I'm going to come on to that, right, because that's really important. And I'm delighted you've raised it. But on the issue of complaint and complaint handling, again, it's well worth looking at the Scottish Legal Complaints Commission to see what sort of complaints are being made and to see what they are requesting. Right, now someone's put their hand up. Is that Cheryl? Or someone's put their hand up, Stephen. I don't know who that is. If Stephen, could you just allow them to access the microphone? And while we're doing that, Stephanie, that was one of the things that I had on my list for the next one of these, is to have a look at case management systems. And we could also have a look at search providers if we wanted. Yeah. And third-party complaints, Jill. All right, so we've got some topics. I'm just going to make a note of this if I can. So we're going to talk about case management systems. We're going to talk about third-party complaints and avoiding complaints. That's fine. Negligence claims, interested or not? And as I say, you know, it shows you how sad I am. I'm a land lawyer. Anyone got any sort of burning land law issues, or any case law that, you know, you want me to sort of investigate or have a look at? Hot topics for negligence, Jill. Yeah, happy to do that. Horrible topic, but let's do it. Anybody else? Okay, we've got 2 minutes. Has today been useful? I'm conscious of it being a first, and I'm absolutely delighted with the number of attendees. I'm really, really pleased with that. That's really great news. Hi, John. I'm really, John's with us, hopefully. Ownerless land, Leslie. All right, yeah, that's another one. I like that one. John, if your microphone is working, do you anything comment, anything to say?
I never saw any of it, Ian. we had a power. All the power went down at 12:30, just as we were ready to go.
No problem.
Phone Scottish Power came back on and went off again. It's just come back on again.
Right.
They say it would be fixed by 2:30, but it's now 1:30. So I never saw any of it. I'm sorry.
Oh well, John, I tell you what, you haven't missed much. Just me rabbiting on. But I tell you what, we have had loads and loads of comments, loads of participation. Stephanie, yep, boundaries, happy to do that. Hey, listen, I love this. It's far better than me just preparing stuff and talking. If you want people to come along and talk, if there's any people that you'd like to participate, let me know. But what all I can say is, first of all, massive thank you to Stewart Title, to Liz and John and Stephen for inviting me along. Massive thank you to you for giving up your time with regard to today. My email address is ian@iqlegaltraining.com. I'll just put it in the chat box there. Do drop me a note at iqlegaltraining.com. Do drop me a note if you have any questions or any queries or any topics for the next occasion. Stephen, can I say, being a bit presumptuous, that this has been a success and that we'll try and run it on a sort of monthly basis?
I think it's definitely been a success. It's definitely been a learning process. I think there's things we can take away. And just as you've put it yourself, Ian, if there's anything that anyone would like to discuss that they maybe haven't put in the chat at this point, then please do get in touch with us, because we do love running these sessions. We've had a couple of years through the pandemic where Ian, you did a fantastic job, and I think we did a fantastic job in terms of talking to people and training, but it's much better, I think, to get that engagement, to listen and understand what issues people are having. But we can only do that if we hear from people beforehand.
Yeah.
Otherwise, we have to kind of go on the topics on the hoof a bit. But so I think if people do have issues that they really want to discuss with ourselves, with Ian, then yes, please get in touch, because we'd love to be running these forums.
Yeah.
And
Stephen,
we will also be running a feedback session as well.
Yeah.
For anyone
Stephen,
like to give
can I just
feedback.
chip in there? I think Jill, can you send me an email about your connection? That's really useful. So I'll have a chat with Jill about her work. That'd be great. Thank you for that. And Stephen, sorry to cut across you there, but I'm conscious of time. I think if there's nothing else, I've made a note of it, what everyone would like to discuss on the last time. We'll make sure that we address those issues. Thank you very much, Stephen. Thanks for sort of manning the chair and looking after the IT side of things. I really appreciate it, as usual. Yeah.
Okay. Take care, everyone. Nice
Thank
to speak
you.
to you.
Stay safe. Bye-bye.
Bye-bye now. Bye.